has an effect on the custody issue. Now, Your Honor, in our circumstance, Officer Wright made a direct accusatory statement towards Ms. Vega, stating, "I told Adrian that we thought Adrian drove the car that struck the bicyclist on Skyline and Grant." After this moment, Adrian Vega was in custody and was due Miranda warnings. The circumstances surrounding this statement were that Ms. Vega was sitting in the back of a locked police cruiser, completely isolated and being directly accused of crime.
2 minutes.
Any reasonable person in this circumstance would feel deprived of freedom and was due Miranda warnings.
Did she know the door was locked?
No, Your Honor. However, Ms. Vega testifies in her own written statement that though she did not know the door was locked, she felt that she was not sure if the officers were going to let her go home that night, and that is an indication of deprivation of freedom. To my second point, Ms. Vega was in a police-dominated atmosphere. In the federal court case of U.S. v. Craighead, the court ruled that there are 4 determining factors to make a situation police-dominated. First, the number of officers present. Second, whether the suspect was isolated. Third, whether the suspect was restrained by any means. And fourth, whether the suspect was told that he or she was free to leave the interrogation at any time. Your Honor, the circumstances in our case were that first, Ms. Vega was outnumbered by 2 officers, Officer Wright and Officer Jackson.
That's not very many officers though, right? It's only 2.
Yes, Your Honor. Compared to the U.S. v. Craighead case, where there was at least 7 officers, this is a comparably small number. However, you must consider the totality of the circumstances, and the 3 other factors will outweigh this unbalance in the 4 determining factors. Secondly, Ms. Vega was completely isolated. She was sitting in the back of a locked police cruiser at 11 o'clock at night, being questioned by police who directly accused her of being the driver of this hit and run. Third, Ms. Vega was indeed physically restrained. Ms. Vega was physically incapable of leaving the back of that locked police cruiser, even if she had tried. And fourth, Ms. Vega was never told that she was free to leave the interrogation at any time. All these factors are enough for any reasonable person in Ms. Vega's circumstance to
30
feel
seconds.
deprived of freedom and not at liberty to terminate the interrogation at any time. For all these reasons, the defense requests that you protect Ms. Vega's Fifth Amendment constitutional right and declare the bracketed statement inadmissible. Thank you.
I have a question.
Yes,
How did Ms. Vega end up in the backseat of the police car?
Officer Wright and Officer Jackson had investigated the scene of the hit and run and investigated that there was a black Bueller involved in the hit and run. They tracked the black Bueller down to the Vega residence and came to the Vega residence. Now, they stumbled upon Ms. Vega and questioned her initially just on the front lawn of the Vega residence. Then, due to the cold, Officer Wright offered Ms. Vega to sit in the police cruiser.
Okay, well, if it was cold outside, it sounds like, it's not too terrible to offer shelter to someone when it's cold outside.
However, Your Honor, we cannot consider this in the Supreme Court case sense of voluntary entering of the vehicle. For example, in the Supreme Court case of Oregon versus Matthieson, the defendant voluntarily, by their own will and accord, made an appointment with the police station to be interrogated. The defendant in Oregon versus Matthieson knew full well that they were going to be interrogated on that day. On the other hand, Ms. Vega, on the night of April 19th, was approached by the police and had no idea whatsoever that she was going to be interrogated that night. This lack of knowledge completely changes the atmosphere of the question.